Let's talk about undocumented workers. My name is Nina, and I'm about to get in your business. If you would like to know more about how to better run your business, solving business problems, human resources, and other business operations topics, you know what to do. Click that subscribe button and smash that notification bell so you'll be alerted when new videos are uploaded. All the definitions in this video are glossed over. If you would like more in-depth information, I recommend you contact your licensed employment attorney. Under the Immigration Reform and Control Act of 1986, it is illegal for employers to knowingly employ undocumented workers. That is, an individual who cannot produce the required paperwork that proves that that person is authorized to work in the U.S. When hiring an employee, your company is required by federal law to request certain documents. I'll make a list of acceptable documents over there. Undocumented workers, illegal workers. These terms are used interchangeably to describe a person who is employed by a company without the required or expired documentation as mandated by the U.S. government. So, if you hire an employee who produces valid documentation and those documentations expire, that employee, regardless of citizenship status, is now an undocumented worker. Please understand, a U.S. citizen can be classified as an undocumented worker if he or she cannot produce the paperwork proving that they are authorized to work in the U.S. Companies are required to confirm work authorization status of each new employee within 3 business days post-hire. IRS Form I-9 is used for verifying the identity and employment authorization of individuals hired for employment in the U.S. All U.S. employers, no matter how small, must perform this task. The I-9 form is occasionally updated by the government, and I highly recommend checking the IRS website at least a couple times a year to ensure your company is using the most up-to-date document. It is up to your human resources department to ensure that no documentation expires during an individual's tenure of employment. Well, how do you do this? Well, I recommend creating some kind of reminder that will alert you or your human resources department to check the expiration dates on submitted paperwork. Alert that employee to submit updated documentation and finally update your HR records. Failure to do so may result in fines and penalties levied against your company if you are audited. And that takes me to my next topic. The I-9 form provides a list of acceptable documents that can be submitted as proof of eligibility to work in the U.S. Employers cannot specify which documents an employee may present to establish employment authorization and identity. Also, employers may be penalized for discrimination for checking documents too zealously or insisting that a particular document be presented. As an employer, you should accept documentation from the I-9 lists that reasonably appears on the face to be genuine and relate to the person that's presenting them. The refusal to hire or continue to employ an individual because the documentation presented has a future expiration date may also constitute illegal discrimination. Employers may be held liable not only for knowledge of a worker's undocumented status, but also for constructive knowledge or having reason to know. For example, Your company receives a notice from the Social Security Administration stating that the Social Security number used on your payroll does not match the name of the person in their database. First offenders could be fined a minimum of $375 per undocumented employee. Subsequent offenses could result in thousands of dollars of fines per undocumented employee. Employers who display a pattern of practice of hiring undocumented employees could be fined up to $3,000 per undocumented employee and or imprisoned up to 6 months in jail for an employer. So they ain't playing. I bet you didn't know this. Undocumented workers in the United States are protected by all employment rights despite their immigration status. Under federal law, it is illegal to discriminate against any worker regardless of immigration status. The Immigration and Nationality Act prohibits discrimination based on citizenship status. I recommend employers not hire undocumented workers and terminate undocumented workers if your Human Resources Department discovers that the employee does not have proper documentation. With that being said, an employer cannot use the immigration status of an individual to terminate an undocumented worker who files a discrimination complaint or exercises their legal rights. Employer retaliation would be breaking the law. Again, for more information, please contact a licensed employment attorney in the state in which your business resides. Thanks for watching.